Good morning, everyone. For the record, this is Tuesday, May 17th, 2022. We're reviewing the Senate File 2673. This is the Judiciary and Public Safety Conference Committee. We're going to start out with testimony, and a number of our testifiers have other plans for this late morning, and we want to move and hear from them right away. So if Mr. Jeff Shorba is on the line, we will entertain his testimony at this time. Mr. Shorba, welcome to the committee. Would you identify yourself for the record?
Good morning, Mr. Chair, and Chairs Mariani and Becker-Finn and conference committee members. Thank you for entertaining my appearance remotely. My name is Jeff Shorba, and I have the great honor of serving as Minnesota's State Court Administrator. So I appreciate the opportunity to join all of you today. So I was asked to appear to discuss our supplemental budget request as it relates to the compensation increases and our cybersecurity request. So first, I was asked to remind the committee about the funding for judge and staff compensation the branch received last session. So during last year's budget setting session, the judicial branch requested and the legislature approved salary increases for just 1 year of the biennium. As you'll recall, the last legislative session began under the cloud of dire financial projections for the state. And it was out of respect for the projected budget deficits that the branch came forward with a very modest budget request. We're extremely grateful that the legislature provided funding for 2.5% compensation increases for judges and court staff in fiscal year 22. This increase represented a 1.95% increase over the judicial branch starting base. Now that the state's budget situation has greatly improved, we are back asking for funding to provide compensation increases in the second year of the biennium as well. And we are seeking funding to increase judge salaries by 6% in fiscal year 23 and create an employee compensation increase pool of 6% again in fiscal year 23. This funding is vitally important to maintaining the high quality workforce we need to keep our courts working efficiently and effectively. As the Chief Justice and I have shared with conference committee members throughout the legislative session, the judicial branch compensation structure has fallen behind our peers in the public sector, which is contributing to the significant recruitment and retention issues facing our courts across the state. We have seen the share of departing court employees increase by 42% since 2018, and we are receiving 60% fewer applicants for each open position in the courts than we were just 3 years ago. Our courts simply can't keep falling behind our peers in the public sector in terms of compensation and continue to attract the attorneys and experienced, skilled staff we need to operate our judicial system in Minnesota. If left unaddressed, these recruitment and retention issues are going to have a very real impact on our ability to carry out our constitutional mission. Which brings me to the next topic I was asked to address, which is how our judges and staff salaries compare to similar employers and how we arrived at our request for 6% compensation increases. In crafting our request for employee compensation, we looked to other public sector organizations for comparison. We conducted a market evaluation and comparison of our salary structure to other public sector organizations, including other court systems and state and local government entities in Minnesota. And I'd be happy to provide you a list of those comparison indices if you'd like or talk about them. This evaluation showed that our current employee compensation structure is approximately 5 to 7% below the competitive market rate. That is how we arrived at our request for a 6% employee compensation increase pool for fiscal year 23. I also want to add that our courts will fall further behind our public sector peers if the legislature does not fund our supplemental budget request. For example, if labor agreements are approved by the legislature, the executive branch is providing step and across the board increases for both years of the biennium. Step increases on average are 3.5%. Across the board increases range from 2 to 3%. So for executive branch entities, we're talking about a range of 5.5 to 6.5%. The federal courts are providing a cost of living adjustment of 3.7% and an annual performance review increase of 3 to 5% for a total of 6.7 to 8.7%. So I can't emphasize enough how important what we believe this modest funding request is to maintain a high quality, high functioning court system in Minnesota. We need qualified staff working in our courts, supporting judges, managing case records, and helping the hundreds of Minnesotans who come into our courts seeking justice each day. The compensation challenges that I highlighted have also impacted the judiciary's ability to recruit and retain skilled and experienced attorneys to serve on the bench. In many counties, the judges serving on the bench are earning less, sometimes significantly less, than the prosecutors who are appearing before them. As you heard in 2020, a study commissioned by the Minnesota District Judges Association compared judge salaries to county attorney salaries in 4 large counties across the state, Hennepin, Ramsey, Stearns, and Dakota, and found judges earning 8 to 23% less than county prosecutors, and in some of those counties less than the salaries paid to the local assistant county attorneys. These disparities suggest that lawyers who feel a call to public service in the state receive financial incentives to serve as county or assistant county attorneys rather than in the judiciary. Each year, the National Center for State Courts releases a report which compares the compensation of judges across the United States. As of the January 2022 study, Minnesota Supreme Court Justice ranked number 24, our Court of Appeal judges ranked number 21, and our District Court judges ranked 20 when adjusted for cost of living. Next, I was asked to explain how our employee labor contracts would be impacted if this additional compensation funding was provided by the legislature. So as part of our FY 22-23 contract settlement, we included language that states that each agreement shall be reopened one time for the sole purpose of negotiating compensation for the second year of the agreement. That means if the legislature provides funding for compensation increases in FY 23, we'd meet with our labor unions to negotiate these wage reopeners over the summer. I was also asked to explain how the judicial branch uses merit-based compensation increases. This is a topic I'm extremely proud of and more than happy to discuss with the committee. We began using merit-based pay in 2008 with our unrepresented non-union employee group. Through this system, an employee's percentage pay increase is based upon their annual performance evaluation score. This system allows us to reward high-performing employees for their exceptional contributions and provides incentives for employees to earn higher and higher evaluation scores each year. To be clear, compensation increases for represented employees continues to be governed by our negotiated labor contracts. Currently, all judicial branch employees must have a satisfactory or successful performance rating to receive a compensation increase. Finally, I was asked to provide the committee an overview of the cybersecurity funding request. Our cybersecurity request seeks $1.75 million per year in additional funding for the branch's statewide cybersecurity program. This was an item that was included in our biennial budget request last session, but did not get included in the final budget agreement. We launched our cybersecurity program in FY 2017, and with the support of the legislature, it has become a critical part of our court operations. As the judicial branch has embraced an all electronic case record and shifted more and more of both our court hearings and backroom court operations to the online world, cybersecurity has become a paramount concern for our court system. Our cybersecurity program not only works to ensure the reliability of court operations and services, but also to safeguard the private and non-public data stored by our courts. This funding would allow us to enhance our information security and risk management program and mitigate the risk of data breaches, data corruption, system outages, document data loss, and cyber attacks. The request specifically addresses necessary training, hardware, and software needs for this effort. So in closing, Mr. Chair, on behalf of the judges and staff of the Minnesota Judicial Branch, I thank you for the opportunity to appear here today to discuss our budget request and some of the major challenges and opportunities facing our courts. We are extremely proud of the amazing work of our judges and staff across the state to maintain an open door to justice for Minnesotans throughout the pandemic. And we are grateful that the legislature is considering using a portion of this historic budget surplus to reinvest in our statewide justice system and to help us maintain what we believe is the high quality and efficient judicial system Minnesotans deserve. Thank you. I'm happy to answer any questions.
Thank you, Mr. Shorba. Members, Mr. Shorba has a looming time conflict, and so we're going to open up for questions or discussion at this time. If anyone has any discussion points or questions for Mr. Shorba, we could do that now. Representative Becker-Finn.
Thank you, Mr. Chair. And I think, just to speak to, I think the thing we talk about a lot is the need to keep the whole judicial system functioning well. We do need to make sure we're supporting, we think of it as a three-legged stool with the public defenders and civil legal and our courts, and that's really important. So I appreciate the courts coming forward and sharing that, because it is really important. One thing I did want to ask Mr. Shorba, because I think it is important for the public's benefit. There's a big difference between a starting salary for someone who's like a court operations clerk versus a judge. And so I'm wondering if Mr. Shorba could share with us the starting salary, what's a base level that we're starting with a kind of starting out in the court's job, like a court operations clerk or a judicial clerk, and then what is the current salary for judges, just so we know the math we're dealing with.
Mr. Shorba.
Mr. Chair, Chair Becker-Finn, the starting salary, I believe, and I'm looking to find out that specific range right now here, for a court clerk is around $18 an hour, I believe. And there is a range, of course. And we are finding now in our court system that we are having to go higher in that range to get people to take jobs in the court system. So that creates issues, equity issues with people who've been around for a while who are maybe not moving up as high into the range as well. So that's something that we are trying to take care of in our negotiations with our labor unions. But there's a problem when you can go to Target and make as much as you do, having to do with a very complicated work of the court system. And I don't have the starting salary of a district court judge, but I can find that out for sure and get that to you.
Representative Becker-Finn.
Thank you, Mr. Chair. And if I remember correctly, I know I could Google it, but it's hard to do both things at the same time. But I think it's around 160,000, maybe even close to 170,000 now. So I just want to make sure we're clear about that. We're thinking of the math. A 6% of $160,000 salary is a much bigger number than 6% of $18 an hour. So just want to make sure we're clear with what those numbers are. Thank you, Mr. Chair.
All right. Thank you. Any other questions for Mr. Shorba? Any discussion? Mr. Shorba, you're excused.
Thank you so much.
Thank you. Next on our list is Mr. Kevin Kyer, accompanied by Mr. Bill Ward, Public Defense.
Mr. Chairman and members.
Mr. Kyer, would you introduce yourself for the committee?
For the record, my name is Kevin Kyer. I'm the Chief Administrator for the Board of Public Defense. To my right is Bill Ward, our State Public Defender. Mr. Chairman, you had asked a number of questions, or I guess the staff had sent us some, so we'll go through there. And obviously, if you all have some questions or something we're not covering, we're happy to do that. The first one was on our collective bargaining agreements. We do have a collective bargaining agreement with Teamsters Local 320, one for our assistant public defenders and one for our support staff. That contract runs through June 30th of 2023. As you may know, for some of the media reports, The settlement was for 3.5% cost of living adjustment effective July 1st of 2021, a 3% cost of living adjustment effective July 1st of 2022, and then step increases as well. Mr. Chairman, you may recall from last year, again, echoing what Mr. Shorba said, when we put the budget together in the fall of 2020, we were putting together a budget at the same time the state was facing about a $6 or $7 billion deficit over the next 3-year period. So we put together what we thought was a reasonable and budget request that included a 1% cost of living adjustment and step increases for staff. That was funded by you all, and we were very grateful for that. What it has transpired, though, is with this settlements, and again, as you've read the media accounts, going forward, we will have about a $2.9 million deficit, annual deficit in the budget. And, Mr. Chairman, as you've heard me say a number of times, and I will for some of the folks that haven't been on the committee, 90% of the budget is personnel. 96% of our budget is fixed costs between personnel, rent, data lines, phones, those kinds of things. And as I've said before, and you're sick of me hearing it, public defenders cannot refuse cases. So it really puts us between a rock and a hard place in terms of we don't have those usual tools that agencies have about leaving positions open in order to fund ongoing deficits or settlement agreements of these types. Over the years, what the board has struggled with and tried to maintain is the balance between hiring staff and also providing for salary and benefit increases for existing staff. That's just gotten to be, in this time, in this age, a very difficult thing to do, hence the $2.9 million deficit. The question was also asked about the salary differences between public defenders and county attorneys. We took a look at this, and actually, Mr. Chairman, we had talked with the House about this. And this is before this settlement, so I just want to be clear that it was before this latest settlement. The entry-level salary for a public defender was $65,800. The 2020, and again, I want to be clear, the 2020 entry-level salary on average for county attorneys in the 10 counties where we have our judicial district offices was about $70,400. I will tell you that, again, that was 2020. Ours was also 2020, but because of the difference in fiscal years, we're always 6 months to a year behind to start with. And I will tell you that the counties have upped their game in terms of those entry-level salaries. For example, Beltrami County is now paying, if not $80,000, it's very close to 80 as an entry-level salary for their county attorneys. The other thing you have to keep in mind is that, generally speaking, those county attorney ranges, it takes anywhere from about 8 to 10 to 12 years to go through the range. So they start at 70,000, they top off at about 135,000. Again, this is 2020 numbers, where ours topped off at about 115,000. The difference is, for public defenders, it takes about 17 years to go through the salary range. So the difference in salaries gets exaggerated as people get more experience, the differences get worse. So by the time, for example, you are at a 10-year public defender experience versus a 10-year county attorney experience in those counties, you may be seeing close to a $30,000 a year difference in salaries. Again, it closes a little bit as you get further down the line, but again, it takes that much longer. Mr. Chairman, I think that the other question was about the appropriation and what we would do. as Mr. Shorb indicated with his folks, we do have a memorandum of understanding with the Teamsters that if there was additional funding for salary increases, we would open up the contracts again, specifically for negotiating increases in those salaries, again, if there's funding provided. You know, in terms of the other question, Mr. Chairman, that you all had asked was about recruitment. Frankly, we haven't had an opportunity to do anything like we may be seeing if, in fact, you all come to an agreement on some additional money for hires. I will tell you this. Back in 2019 and 20, we had a hiring freeze, anticipating, again, where you all had that $6 or $7 billion deficit, that there was going to be some need to generate some kind of savings in order to maintain our staffing. So we had vacancies of about 50 attorneys, and we contacted, I think it was 43 or 44 law schools, basically from Ohio west to Montana, Wyoming, Colorado, in order to get as broad a net as we could find in terms of recruitment. We have worked hard, our chiefs have worked hard at getting a workforce that better reflects our clients. We're going to continue to do that. But the big issue we have, frankly, is recruiting into greater Minnesota. And we have made inroads with the law schools in North Dakota, South Dakota, Wyoming, places like that, where we can attract people who have an appreciation for living and working in greater Minnesota. Our biggest challenge in terms of recruitment is the 7th District, the 9th District, parts of the 8th District, that part of kind of central and northwestern Minnesota. There are jobs that we open there where we don't get any applications, and hasn't been unusual in the last couple of years. So, as Mr. Shorb indicated, we're seeing some of the very same issues in terms of recruitment and retention. We had 11% of our staff resign last year during 2021. That doesn't include retirements. It doesn't include judgeships. That's straight out resignations. We are seeing on the recruitment side somewhere between half and less than half of the applications or the applicants that we used to see when we open up positions, and that's statewide. I mean, it's more pronounced in, as I said, the 7th District, the 9th District, but it's also in Hennepin and Ramsey County as well, and the metro area. So, Mr. Chairman, I don't know if I've covered everything that you asked or your folks asked, but obviously we're happy to answer any other questions that folks may have.
Any questions for, yes, Representative Becker-Finn.
Thank you, Mr. Chair, and I just think it's really important that we lift up the fact that the funding of our public defenders is one of very few things that our Constitution, the U.S. Constitution, requires us to do. And so I appreciate the work that's gone on in both houses to move this issue forward. I think we kind of got over the years in a bad habit of only asking for tiny things because we thought that's all we could dare to ask for. And I've really, pressured people to ask for what we need. What is it that we need? And that's just so that's on the record in this conference committee, that the $50 million a year, we asked the question, what would it take to fully fund our public defenders so that our caseloads are at least meeting the bare minimum, national standards of being able to have those caseloads where they need to be. Because the reality is that public defenders are people, and they're only 24 hours a day, and there's only so much you could do if your caseload is too big. And so we asked that question, and the answer we got was the $50 million a year. And so I just think I want to make sure that's on the record, that's where that wasn't some imaginary number we came up with. We specifically asked, what would it take to do this right and do right by the people of Minnesota, fulfill that duty that we have as a state to fund public defense. So, I just really wanted to highlight that and appreciate your willingness, Mr. Chair, and folks being open to thinking a little bit differently instead of just biting off tiny pieces, but like, let's talk how we build a system that actually meets our requirements and really what our duty is as a state, and I think both you and I, Mr. Chair, take it very seriously, our duties to fund that three-legged stool and make sure that we have a functioning judicial system that works for everybody. And so I just really want to lift that up, how important that is, that number, and that's where our focus is, and it really should be. And I appreciate that that's the inclusion in both bills. And so, yeah, focus on what you need. We will never get to an actual functioning system if we don't start by talking about what we need. And so I think that's just really important as we do this work and move forward in this conference committee. So thank you, Mr. Chair.
Mr. Kyer, I don't know if there's a question in there, but you're welcome to give a response.
Mr. Chairman, I don't think there's a question, but Representative Becker-Finn, thank you for that. This is as you've mentioned before, this is really an unprecedented time in terms of the budget surplus you all have. And frankly, the turnaround, if you remember, as I said, when we were looking in the fall of 2020, we were looking at a $6 or $7 billion deficit, and now you're dealing with a $9 billion surplus. I mean, I've been doing this work a long time. I've never seen that kind of a turnaround. So, Mr. Chairman, I would add one thing in the spirit of asking for what you need. The one issue that we had that we raised with the House is right now the state public defender salary is governed by Minnesota statute 611.23, and it's tied to that of a district court judge. If we are fortunate enough to get funding for salary increases, we have already and we will continue to see salary compression where even right now on July 1st, we're going to have the state public defender making less than some of the folks, the chief public defenders that he supervises. And again, if we're lucky enough and you all see fit to put that salary budget together, we're going to have that same situation among our assistant public defenders versus our managing attorneys and then our chief public defenders. So, just something to keep in mind, Mr. Chairman, if you're going to go down that path, we sure would appreciate you having a look at that.
Thank you.
And Mr. Ward didn't tell me to say that.
I did not.
It was a surprise.
I know what
to
a
him,
judge makes, I can tell you that much.
I've dealt with Mr. Ward before. Mr. Kyer, I have a question. As a result of the COVID restrictions, the courts have a backlog in cases. Can you just give us a glimpse of what we're looking at as far as how it affects your public defenders? Are we beginning to reduce that caseload, or do we still have quite a challenge in front of us?
Yeah, Mr. Chairman, I'll just, a couple of brief comments, and I think I'll actually ask Mr. Ward to address that because I think he's probably got a little more up-to-date information. We started with about a 13,000 case backlog. There have been a couple of counties that have reduced that backlog considerably. There have been a few, but I will tell you those are also the counties where our folks are burning out and are quitting. In fact, we had a couple of those folks who spoke to the House committee. We had a couple of folks, or a couple of letters that we read into the record in the House about we've had 10 and 12 and 15-year lawyers who have left specifically because of those pressures of those backlogs. And you just don't replace that kind of experience. But I know Mr. Ward probably got some comments on that as well.
Yeah, Mr. Ward, would you identify yourself?
Certainly. Mr. Chair, Bill Ward, on the State Public Defender for Minnesota. I think it's important for everybody to know that we were one of the few states that actually litigated trials almost the entire time of COVID, except for the first 3 months. We had pilot programs in 7 of the counties in the state, and we looked at what the COVID rules would be, and frankly, our chief public defenders and managers literally measured courtrooms to see whether or not we could do trials. We did that throughout the state, so that's something all of us should be proud of. It wasn't as we just stopped doing the work. We continued to do the work under a lot of pressure, obviously. Yes, there is a backlog, and ultimately it's going to take a lot of work to get through that backlog. The goal is by June of 2023. Judge Small's in the audience today. He and I were at a meeting last week with the Chief Justice and other members of a task force to look at, as we move forward, what the different plans will look like in the district. As I said in the meeting, to provide for a lot of local rules, it's going to be chaotic at the onset to see how this is going to work, let alone county by county, let alone district by district. But ultimately, the task force is going to continue to meet to see how these cases are being dealt with in person through anonymous hearings, contested anonymous trials, and whether or not we can still continue to do remote hearings, which have proven to be very efficient. I would also tell all of you that I would never have said this 10 years ago. I've been in support of having remote hearings for non-contested cases. Frankly, as a lawyer, I like seeing my client in court, but it's proved incredibly helpful to our clients who don't have to take off of work, they don't have to have child care, and frankly, the failure to appear rate has gone way down as a result of having the ability to have virtual hearings. So I'll continue to work with the court on that. And again, I would never have said that 10 years ago, but it's been really, really wonderful for our clients. One last pitch is to all of you, with this budget surplus we have, we need a much, much robust internet service provider outstate in Minnesota. I have too many clients who are going to McDonald's, to the libraries to use the Wi-Fi there to have their hearings. And it's also important to remind not all of you, but certainly the courts, that our clients are using their phones for these hearings. They're not using fancy laptops that I have sitting here. And as we go through this, to work through how that's going to look, to understand poverty, to understand the ability to have the tools that all of us have. The clients don't have all that. So we're working through that. We've had really good reception with the courts on this issue as well.
Thank you. One other point while we're on this subject, and Mr. Shorber had to leave, but I also was told by the folks in the Supreme Court that 17 district court judges decided to retire also. And they were also mentioning part of the reason was a burnout. And so we do have a serious issue as far as maintaining our third branch of government. Mm-hmm. So any other questions? Representative Mueller.
Thanks, Mr. Chair. Not a question, but just emphasizing again that that's also happening with prosecutors as well, with the high caseloads and the burnout that was mentioned yesterday, and difficulty in filling some of those positions. So it's just an area that we need to be mindful of, and I'm glad we're shining a light on this. Thank you.
Right. Seeing no further questions, thank you, gentlemen, for coming. Next on our list is Mr. Edward Reynoso from the Teamsters. And Mr. Reynoso, did you have another guest that you wanted to have at the same time, or is that separate?
Mr. Chair, I'm just going to be very brief on the front end, then I'll turn it over to
Why don't you
Scott
introduce
Noakes.
yourself for the record, and then please proceed.
Thank you, Mr. Chair. My name is Edward Reynoso. I'm the Political and Legislative Director for Teamsters Local 320. We represent over 700 public defenders, assistant public defenders, investigators, and support staff. First of all, I want to thank both chambers and show appreciation for both the Senate and the House, virtually identical proposal when it came to funding the public defenders and their omnibus bills. What our members heard was this was going to be real caseload relief and a real opportunity to recruit and retain fellow co-workers. The reality is overloaded public defenders lack the time and time for investigations. They lack the time to review and the discovery materials and perform legal research and file motions, communicate with clients, and prepare for court. The only way this is going to change is fully funding the system. A well-funded and functioning public defender system ensures that the constitutional right of the indigent are protected. And as was already mentioned by Representative Becker-Finn and others today, The $50 million wasn't just grabbed out of the air. This is exactly what the Board of Public Defense testified that was needed to be able to run an effective public defender system. Part of it was going to be they needed for parity, and the other was for recruitment, hiring, retaining staff to the American Bar Association standards of caseloads. Reducing the $50 million would not allow the Board of Public Defense to reach these goals, as I just mentioned. Mr. Chair and committee members, I could go on and talk about some of the issues that concerns we see with reducing the amount. We honestly respect the position that the Senate GOP has put out, but we respectfully ask that you reconsider and increase it back to the $50 million. I can go on, as I said, but I'm going to turn it over to somebody that lives day in and day out what it is, what it takes to be a public defender. And it's Scott Noakes. He is an assistant public defender. He's a veteran of the Navy, very smart gentleman. He has a PhD, and he after retiring from the Navy and doing all this other stuff, he decided he was going to continue to give back to his community by becoming a public defender and continue to serve. So, Mr. Chair, I'd like to turn it over to him, and I'm more than willing to answer any questions.
Thank you, Mr. Reynoso. Mr. Scott Noakes, welcome to the committee. And before we begin, thank you for your service. We greatly appreciate that.
Thank you, Mr. Chairman, members of the committee. I'd like to also thank Chairman Jamie Becker-Finn for her support and leadership throughout this supplemental budget process. And, you know, again, my name is Scott Noakes. I'm an assistant part-time public defender here in McLeod County. I've been involved with public defense since 2008. And after retiring, actually, it was from the U.S. Coast Guard. I was in the Navy first for 9 years, and then Coast Guard. I retired back from active duty in 2004. Went to law school at Hamlin on the weekend program, and was lucky enough to become involved in public defense. I was asked to speak about a couple things. First, about caseloads. Caseloads are too high, as testified already by Mr. Kyer and Mr. Ward. They know all too well that caseloads are too high. You know, a good example of that is that just last month I was appointed to represent a man named Casper Casey for third-degree murder here in McLeod County, providing methamphetamine to a lady that later died, allegedly because of this methamphetamine toxicity overdose. That case is going to, you know, take about a couple hundred hours, maybe 300 hours of time. But how much time do I get per case when you take the, you know, number of hours that I'm allotted by public defense for part-time is about 1,365 hours per year, about 300 cases. If we do the math, that's about 4.6 hours per case for the whole case per year. So I'm going to volunteer a whole bunch of time on this case to get Mr. Casey taken care of. Lots of things involved. Coroner reports, experts, toxicologists, thousands of pages of discovery and reports to review, maybe a 2-week trial. But I get 4.6 hours from the system. That's one example of why it's critical that that caseload be addressed. Another reason why retention, as testified to by Mr. Kyer and Mr. Ward, that people are leaving our system in droves that are well-qualified attorneys that are just burned out. They don't want to deal with it anymore. And we need help to reduce that caseload so we have more time, because time, Mr. Chairman and members of the committee, is the secret sauce of justice. It really is. We need time to do all the things that are required to properly represent each and every one of our clients. Because I can assure you that every one of our clients believes that their case is the most important case. I was also asked to speak about the issue and specifically about the constitutionality of public defense, and I'm happy to do that. Representative Glenn Gruenhagen actually is office here in Glen Minnesota, here in McLeod County where I am, came over to my office and I think quite frankly he was a little skeptical about fully funding public defense, but he asked me, is this a want or a need? And apparently that's pretty important there at your level. And he concluded this is a need, not a want. And also Senator Scott Newman, who was himself a part-time public defender many years ago in the contract system, is very supportive of public defense as well. And they both agreed to support fully funding public defense because it is a need, not a want. Why is that? I want to talk a little bit about that. The constitutionality of public defense goes back to the case of Gideon versus Wainwright back from 1963. Mr. Clarence Gideon was a gentleman who was a resident of Panama City, Florida. He was accused of breaking into a pool room in Bay Harbor, which is a bar, in Panama City, Florida, back on June 3rd of 1961. And there was some report that he had left, well, there was somebody that broke into the pool hall, smashed a bunch of old, coin-operated machines, took some change, some wine, beer, some Coca-Cola, and took off. Well, Mr. Gideon was seen in the area sometime the evening before, carrying a bottle of wine and maybe and accused of having some change in his pockets, and was charged with a crime for petty larceny and breaking and entering. And he was poor, didn't have an attorney, stood trial, asked for an attorney that was denied, represented himself, was found guilty, and went to prison for 5 years in Florida. He asked the Supreme Court of Florida for an attorney on appeal, should have a new trial, and they said no. So what does he do? He writes on jailhouse letterhead in pencil to the United States Supreme Court asking for a new trial, saying that he should have had an attorney representing him through this process. Everybody was rolling their eyes, and oh, there goes Clarence again. But to everybody's shock and amazement, the United States Supreme Court took his case. And what's the first thing they did? They appointed Abe Fortas, who was a well-respected attorney in Washington, D.C., to be his attorney. And eventually, the Supreme Court of the United States ruled 9-0, unanimously, that he was right, that he did have a right to an attorney under the United States Constitution. And that would thereafter apply to all 50 states. Well, he wasn't let out of jail, but he did get a new trial. And at that trial, he was appointed an attorney, a local defense attorney, who was, I guess, the first public defender. That public defender found a taxi driver who gave a ride to Mr. Gideon from that area and said he didn't see any wine, any beer, any Coke, and certainly didn't have bulging pockets of change. And based on that testimony, Mr. Gideon was later found not guilty at his second trial with his public defender. Mr. Gideon was I think died in 1972 in an unmarked grave in Missouri. Later, his family put a marker there, and there's a saying on there that was actually a quote from a letter that was written by Mr. Gideon to his attorney, Abe Fortas, and says, "Each era finds an improvement in the law for the benefit of mankind." Interestingly, Clarence Gideon's middle name is Earl, which is my dad's middle name, my grandpa's first name, so we have that in common. But that's why this is a need, not a want. We need this money to honor Mr. Gideon's memory, to make sure that we're doing the best for our clients. And quite frankly, it's a difficult job. Navy was hard, Coast Guard was hard. This is harder. Every day, we're pushing the rock up the hill, representing our clients, doing the best we can with the resources that we're given. And we're begging to please fund public defense for the full $54 million that's being requested. It's important to us, it's important to your constituents to to provide them with the resources that are necessary to represent them to our best of our ability. Thank you.
Thank you, Mr. Noakes. Anyone have questions for this testifier? Yes, Representative Fredericks.
Thank you, Mr. Chair. Brother Reynoso, good to see you. And thanks for bringing Mr. Noakes. Mr. Noakes, I just want to say what you just laid out. I used to practice as a public defender in Hennepin County, and I also clerked there. And what I learned was that many of the attorneys there at the time I was there, so a while back now, but they were lifelong public defenders. They care passionately about the people that they serve, and they care passionately about doing the work of an attorney and doing it the best way possible. The story you just laid out very eloquently about Mr. Gideon, every time a client comes into that court and has to be appointed an attorney, that is a Gideon. And every time they don't get the adequate services that they need because we haven't provided the resources, there is an opportunity that they could get the initial outcome that Mr. Gideon got. I think that Minnesota has been a leader in many ways in terms of how our public defense system has been set up. That is why many of the attorneys that worked in that office were lifelong public defenders. But every year that goes by that we don't provide the resources necessary to run that office the right way, to take care of the constitutional right that is required for poor folks that come through this system, many of them black and brown and indigenous folks. We're setting up an opportunity to take a step back to a time before Gideon was able to have the requisite representation that is now required. So I will say, Mr. Chair, I hope that we can, as we go through these negotiations, get back up to that 50 million number, because that is the number that was told to us that is needed to do the right thing and to have the representation that's necessary for our poor folks in Minnesota. So thank you both for being here today. Thank you.
Thank you.
Well, thank you. And if I could just add, Chairman Limmer, that
Mr. Noakes.
Thank you. The right to a trial, to a jury trial, is an important right, and it's the only right of all the rights we have, that's contained in all three of our founding documents: the Declaration of Independence, the Constitution, and the Bill of Rights. It's that important. Our founding fathers were adamant about the right to a jury trial, and that's what we do. Thank you.
Thank you, Mr. Noakes. Any other questions, concerns? Senator Johnson, then Becker-Finn. I'm sorry, I called you a senator.
Yeah, I was going to bring that up. Don't wear that powdered wig. I want to thank all the testifiers today. One thing that concerns me.
Could you pull your mic close?
As a police officer, we've tried to put a case together, and we did our best to make sure that we charged and arrested the right person that committed the crime. Do we make mistakes? We're human. But for those that are needed, the public offenders are also important as well, to make sure that the law enforcement officers are doing their jobs properly and making sure that they're convicting the right person or charging the right person to bring him to court. The public defenders make it a balanced way to make sure that both sides are working properly. This year we have we have a historic amount of surplus revenue, which shows me that we have a historic level of surplus taxation. We have a lot of things going on. Part of the problems we have to deal with, what sometimes the public safety and the judiciary get hit hard on, is the fact that the federal government does a lot of mandates in health and human services and education and don't live up to the funding promises they want, and leaves the taxpayers of Minnesota making that up, and which draws away from the funds that we normally have to use the constitutional required issues that we have. So I want to do as much as we can to get the public defenders where they need to be. But until our federal government starts doing the obligations that they also committed to the states, it does make it difficult. Thank you.
Thank you, Representative Johnson. Representative Becker-Finn.
Thank you, Mr. Chair. And I think one thing to highlight too is that, we can talk about specific cases, but the reality is that every single one of us at this table has a friend or a family member, somebody we know who has needed a public defender at some point in their life, or civil legal services at some point in their life. And I think I'm also previously clerked in Hennepin County District Court, and Mr. Sharba isn't here, but if you ask a judge how trials go and how cases go when you have an unrepresented, a pro se litigant in front of you, and the reality is that our legal system is complicated, and people need to have that representation. Even as an attorney myself, I'm in the process of opening a small business, and learning all that new area of the law is very complicated, even as an attorney. And so I think, the expectation that folks would be able to go through an entire criminal trial without representation, that doesn't go well for anyone. It doesn't make the system more efficient. It doesn't make anything work better. And, I just think our access to justice should not depend on our access to wealth. And I think that really is the heart of what the Gideon case stands for. And, we also have Supreme Court cases that say, in addition to Gideon, we also have precedent saying it's the duty of the states to pay for this. And, of all the things that are sort of on the table, I think this does rise to the level. And I also, again, want to thank Mr. Noakes for all of his service in various different ways, and taking the time this morning, because we know his time is very valuable, and I really appreciate him taking the time to testify today. Thank you, Mr. Chair.
Thank you, Representative. Senator Latz.
Mr. Chairman, thank you. I first want to say that, in my experience, some of the best criminal defense lawyers in the state are public defenders. They take on the toughest cases. They don't really have a choice. It's forced on them. And that's the system, and they go into the job knowing that that is the case. They do absolutely their best work, and the public defender clients are fortunate to have those lawyers representing them. They are extraordinarily overworked. The example that Mr. Noakes gave of 4.5 hours per case, that may be fine for some cases. Some cases you can read the police reports and get a pretty good idea of what's going on. But you still need to have time to talk to the defendant and maybe look through the videos. And especially now, almost every case has body-worn camera or squad videos or booking videos. I've won cases solely on the strength of something that happened in the booking room that never shows up in a police report, but it was on the video, and you only find it if you've spent an hour or 2 or 3 going through the videos just to find out what was said and what happened. There's a constitutional violation, evidence gets suppressed, and the result is the charges get dismissed, or you have, you end up changing the outcome of the case in one way or another. Just the time it takes to do that would use up half of the 4.5 hours Mr. Noakes has identified as available for a case, and that might be in a misdemeanor, theft case, let alone the felony cases that, will have 10, 15, 20 hours worth of video to watch, and legal research to do to find out if there's a legal issue, and then you got a memo to file and a brief and a contested hearing. over some of these issues. And when the stakes are 5, 10, 15 years in prison or life in prison, you've got to unturn every possible bit of evidence that is there. Otherwise, I mean, the system is designed for that kind of combat by humans in a courtroom instead of combat on the street. And if the sides are not equally resourced, it's not a fair fight. And the stakes are incredibly high. So I think it's not only a matter of constitutional threshold issues, but it's a matter of justice in the system. And it'd be little comfort to tell a defendant, for a public defender to say, well, you know what, listen, I really need to put about 10 or 15 hours into your case, or 30 hours into your case. I don't have the time to do it, and our office doesn't have the resources to do it, because the federal government is not paying what they should be to the Health and Human Services budget at the state government, and therefore we didn't get the budget we need out of the Public Safety Committee or the Judiciary Committee at the legislature this year. I mean, for someone who's going away for 5 years as a result of an inadequate investigation or something that got missed because it just wasn't the time to do it right, that doesn't help them any. So I'm very frustrated that the leadership gave us a target which is in fact a couple $1 million less than the original Senate target when it left the floor. We came in at $199 million and out of this committee, and then a couple $1 million were added in finance on top of that. And then we end up not only far less than the House, but less than our own original Senate number. And so that's a frustration and a reality we have to deal with, but we also know from past experience may not be the end game if we decide we simply don't have the resources to do the job right here. So I would urge us to stiffen our backs a little bit in that regard and do what we think is necessary to fund the portions of our budget that we're responsible for. There's no doubt in my mind that the full funding level for the public defense is a critical piece of that budget. Thank you, Mr. Chairman.
Thank you, Senator Latz. Mr. Reynoso, you're still here.
I haven't been told I could leave.
Would you,
Mr. Chair.
My mistake, I guess.
I can keep going if you'd like.
Mr. Reynoso.
Don't give up the floor, Mr. Reynolds.
Mr. Chair, I'd really like to personally thank you for allowing us an opportunity to come and tell our story today. You know, at the end of the day, somebody's freedom shouldn't be hinged on their ability to pay for an attorney. So this is certainly something that is important to us as an organization and us as a society. So we leave that in your hands as a committee, and we hope that you help us along the way. Thank you.
Thank you. I do have a question for maybe Mr. Kyer, and I'll hold that. Mr. Reynoso, you can go back to your seat. Thank you. Mr. Kyer, as we consider the budget request, as you know, we asked the Public Defense Bar to give us an idea of what they needed. And with the collective bargaining discussions that were going on almost at the same exact time, I believe that's how we arrived at the first dollar amount, the $50 million. Now, we ask all sorts of government agencies and departments, as well as elements in the third branch of government, the judiciary, to give us ideas of what their budget should be. Then it's up to us to decide with available funds, how do we split the pie? How do we move these numbers around? And my question would be is, what do you need to manage the immediate need right now, such as a question like this? How many unemployed attorneys are out there that need time to ramp up, get hired, and perhaps even get trained so that they can be ready in a courtroom in that time period? Because I would imagine that might take an element of time, would it not?
Mr. Chairman, yes, it would. I mean, you and I have been around this process a long time. We're not going to have everybody on July 1st. What I will tell you, though, is in terms of recruiting those lawyers and support staff, the salary piece is something that's got to be addressed, because otherwise we're just going to be back in the same situation we are now, which is we can't attract people, and I think you heard Mr. Shorba say the same thing. So, you know, the big question the big key for us is the 50 million. It's what we put out there. We really need that 50 million going forward in the future years, because we can't make commitments to hiring to salaries now and not have that money starting July 1st of the new biennium. So, you know, we'll work for this year. We'll work with, you know, whatever the committee deems necessary, or what you can do. But it is critical that we have that money going forward. That's, you know.
All right. You had made mention earlier about the possibility of hiring attorneys from other states. Is there a time factor involved in, or a bar certification that they would have to pass bar in Minnesota in order to practice law here?
Mr. Chairman, there is, although that's been eased quite a bit, so that hasn't been a big concern. We can get them in and get them started. We hire a number of folks, frankly, even from Minnesota, before they pass the bar. And then their continued employment is contingent on them passing the bar here. And that's actually been very successful for us, because we've been able to get in and get some of the folks just graduating from law school. We've also been working with some of the law schools about having a third-year program where we hire them as lawyers, and that's their third year of law school rather than going to class. We'd like to see if we can get more of that going as well. We've done it a little bit. And it's been helping us in terms of getting some folks out to greater Minnesota as well. So it does take some time. I'm not going to kid you, Mr. Chairman. Like I said, we've been doing this a long time. It will take some time for us to get all of those folks on staff and going. But we got to try.
And Mr. Geyer, what's the job market like out there for attorneys as far as wanting to be a defense attorney? Do you have a ready supply? Is it hard to lure them in? You know, some of us who are mere mortals and not an attorney, you know, we don't know. So yeah. Could you give us an
Well,
idea?
you and me both, Mr. Chairman. You might have forgotten that. But, you know, it is, like Mr. Shorba indicated, we're seeing the same things. Recruitment is tough right now. You know, we got hit by the Great Resignation just like everybody else did. It is tough, but again, I will go back to, and it's like a broken record, but we've got to get those salaries, particularly those entry-level salaries, up where we can compete with the other public sector agencies. We lose, last year I told you we lost about 11% of our staff to resignation. I would say a third of those, maybe more than that, went to other public entities. You know, they're not going out to start their own law firm. They're not going out getting a high-priced job at, you know, one of the downtown law firms. I mean, there are a few of those, but not many. Most of them are going to other public agencies, either here or in another state. So that's really kind of where our competition is, if you will. So.
All right. Well, thank you, Mr. Geyer. Any other further questions? Oh, I'm going to go with Representative Fredericks first.
Thank you, Mr. Chair.
Frazier, I'm sorry.
No worries. Thank you, Mr. Chair. Just on a personal note, when I joined Hennepin County Public Defender's Office, my reason for leaving was because of budget cuts. And I did not search or seek out a private firm. I went to another public entity. Salaries were higher, but I left because of budget cuts. And I do some mentoring. I work with St. Thomas Law School, and there are plenty of lawyers that want to go into the work of public defender, and one of the biggest barriers is that they've got student loans, and they need to be able to afford to pay those loans. Mm-hmm. And so that's one of the barriers, but there are folks out there ready and eager to do the work.
Representative Becker-Finn.
Thank you, Mr. Chair. And on the same path, you know, I just double checked. It's 2021, there were 250 graduates from Mitchell Hamlin. We are, depending on how you look at it, we're lucky in that we have a robust law school community in Minnesota. You know, we do turn out a lot of graduates between the three schools. And I can tell you as someone, I'm an adjunct teacher at Mitchell Hamlin and have mentored many law students over the years, and many of them want to do this kind of work, but when you're doing the math, you know, you kind of think of the average grade. You could go back to law school if you wanted to, but you know, the average graduate is, you know, in their 20s. You know, you have to think of your career and your family and how you're going to support yourself, and the math just isn't there unless you really are one of those people that's super dedicated to the public service aspect of this. And I think there are more attorneys and law students who would love to go into this work if they knew and had that certainty that the job was going to be there and that it was going to, you know, not going to burn them out right away. So yeah, that's my personal background with this. And you know, starting out in the public sector right out of law school is really hard, especially, you know, add kids, mortgage, and everyone likes to think attorneys are like attorneys on TV, but that's not the reality for many of us, especially if you go the public service route. So good questions. I think it was important for us to talk about this too. Thank you.
All right. Thank you, Mr. Kyer.
Thank you.
Appreciate it. That'll conclude our testimony time in our committee hearing. Yesterday, the Senate Republicans had a version of a global offer that we presented. That was about 18 hours ago. We posted it so that the public could see what we're up to. And I was wondering if there was any reaction from the House. Chairman Mariani.
Thank you, Mr. Chair, and my apologies to the testifiers for coming in a little bit late today. I thought today's discussion was awfully important, and I really want to preface everything I'm about to say by saying this: 6 days. 6 days. The last time in which this legislature can vote on a bill is at 6:59 a.m. on Monday morning. 6 days. Less than 6 days, quite frankly. I thought the testimony here was incredibly important, Mr. Chair. You know, that idea of that sharing of really good people being burned out is, in my mind, a reflection of our lack of action, commensurate with the need, and it is a need that exists in Minnesota. And that delayed response on our part has produced a severely under-resourced, constitutionally required sector in our state. And it's just one issue that's before this conference committee. I don't know, based on everything we just talked about, all the testimony we had, all the friendly give and take with the individuals who came and testified today, given where the House and the Senate both came in, which now we're farther apart, thanks to the Senate's presentation yesterday, but where we both came in, I don't know why we cannot move that provision right here, right now. Members, yesterday the Senate walked in, you know, and it's all fair here, you know, with absolutely no notice, even though the House had been constantly noticing and sharing information, literally walked into this room and put before us a offer, which basically offered the Senate bill. That was what was put before us to apparently move us toward an agreement. Let me point out, members, that what was put before us in terms of change from the Senate bills, yesterday we're told it's a different place, but it's the starting place. It does so by making small modifications to Senate provisions, provisions that the House doesn't have, but that we certainly have expressed an openness and willingness to move toward the Senate. Provisions on new sentencing for imprisonment as new technical adjustments to required serving of time. New provisions on fentanyl. We had quite a discussion about fentanyl here. We made it real clear where we could conceivably meet. We made it real clear that the House had at least an hour debate on this issue. Ignition interlock, which we tried to offer, and the Senate had earlier rejected. And then some minor movements in the County Corrections Act. What was put before us, as I already mentioned, moves away from the House, not towards it, which is what you have to do in any reasonable conversation, negotiation. It's nice to have the Senate repeat its position, but we know it. What's important is to move toward one another. That proposal cut out $10 million from the public defender appropriations. We heard from the PDs just now that that 50 million level, actually the 54 million level, is really what's needed for this incredibly long-delayed, under-resourced, important sector of our society. What was put before us with a $450 million target that we've been given over 3 years makes incredibly small, tiny steps towards the House, like accepting a $10,000, 10,000, not a million or 10 million, $10,000 bed impact cost for qualified domestic violence offenses. We think that's important. To consider the scale after having been lectured here by the chair of the Senate that we should be doing big things and not these little things. So $10,000. Accepting a savings to the general fund of $114,000 for Ramsey County fines, work that the county did, not the legislature. A fiscal impact that simply should be acknowledged and, quite frankly, not subject to an agreement. You know, the numbers are what the numbers are. And then there was a proposal to accept an effective date. An effective date. That's the element of the big global offer put before us. None of these issues are not important. It moves the governor's BCA request, surpassing the House, what the House proposed. I don't know what you call that. I mean, that's either, in my mind, you either move forward towards or away. This sort of just moves. You know, the House, and it's a fair debate, the House came in not with the governor's number on this, but frankly, to reflect our concern about to what extent our state BCA, it's a fair debate, to what extent it should be conducting local policing functions, which, by the way, the House is looking to help build support for, help build capacity for. The proposal accepts tiny provisions in judiciary issues after ignoring larger provisions where there is de facto agreement and non-controversy. Members, the House tried to avoid this slow walking approach, 6 days, keep that in mind, by trying to focus our votes over the last few days on building from where there are large agreements. The senators, at least on the majority side, literally abandoned their conference committee chairs, their seats, in walking away from those votes. And mind you, the Senate majority also cost us 2 days by not being present on last Friday, not being present on Saturday when they had the gavel, in order to attend a partisan event. We're going to have my party's partisan event this weekend. You know where I'm going to be? I'm going to be here. Because the people of Minnesota elected me to be here to take these votes, to exchange these ideas, to move forward our public safety. They didn't elect me to go attend a state partisan convention. As important as that is, I know where my priorities are. Actually, we know where everyone's priorities are right now. The offer does nothing to respect the principles that the House laid very openly, transparently forward when we started. Dollar for dollar appropriations for law enforcement and community-based public safety. County corrections reform for new county funding. Support for crime victims. I thought it was pretty clear. You don't see it. You don't see anything that responds to that in this offer. I don't expect the Senate to carry the House provisions. But in a negotiation, you've got to move towards one another. And we've been signaling that for days, because we didn't want to get to 6 days. And we carved out a way for us to create a culture, not of trying to best one another, but a culture of building a bill and building it on precisely those things that we de facto agreed to. So, Mr. Chair, let me tell you what I think is going to happen with less than 6 days in session, and you can certainly choose to ignore me, but I've been here for 32 years. There's not a whole lot I haven't seen. And even with that, quite frankly, I have chosen to consistently engage with you, with the other body, with my colleagues, who I bang heads with quite a bit, as openly, as honestly, as deferential as possible. That's my expectation. I don't need that to be yours or anybody else's. You know, Mr. Reynoso, I was hoping I was trying to figure out a way to ask you a question in Spanish, but I just couldn't come up with anything, so I missed my opportunity. Hey, I'm Puerto Rican. We lay our stuff on the table. We play games, we play dominoes all the time, but there are bounds, there are rules, there are norms and expectations, so that the game could be as hard as possible but be done in a way where we actually get the game completed. So let me tell you what I think is going to happen. And I'll give you some advice, Mr. Chair. The House will offer a judiciary component, my understanding is that it's already been floated, to at least try to get to an agreement where we are currently the closest. We were closer 2 days ago, but still. And that's critically important as evidenced today by the testimony. I would advise the Senate to take it. That's my advice. And not leverage our courts and our public defense, which are functions that are constitutionally required, against everything else in this bill. We can do that. We should do that. My further advice, Mr. Chair, and I don't know what your intentions are, but my further advice is don't give up the gavel after this committee is over. Keep it so we have today to shape whatever we can. And I'm telling you this because as someone who's been around for 32 years, and since there seems to be this thinking that we have endless time, as evidenced by totally ignoring the public safety principles that the House openly shared, and since the Senate has already resisted formally agreeing to what we in essence already agreed to, this, in my opinion, will very likely be the last day that we meet in conference. It's just logical. Slow walking through 6 days. If I'm the head of the Senate or the head of the House, I can't afford that. I need us to move if I'm them. And so what most likely will happen is that, and rightly so, within bounds, that we'll have others make these decisions for us. Folks up the ladder from us. So we really need to make the most of what's before us. It's immensely difficult to do that when there's no movement toward one another being demonstrated here. You can bet our leadership's watching these hearings and tracking our progress, or quite frankly, our lack of it. And you can bet they'll do what they need to do in order to be responsible leaders. It's not a partisan issue. So, Mr. Chair, I would suggest that we make the most of today. And I have to say, I just fail to understand how ignoring those areas where we agree, resisting taking action on those where we agree, ignoring the principles of each house, in the offer ignoring the principles of the House, I just don't understand what the goal is. Because it sure doesn't look to me like the goal is to get to an agreement. Certainly not within 6 days, which frankly really means at best 5 days. I'll tell you what my goal is, and has always been, all the years that I've been here, which is to get to agreements for me to accept things often that I don't like. Because obviously, if you haven't figured it out, I play a pretty long game. I played a 32-year long game. To get to agreement, to do that with honor, to do it with transparency, and to do it by listening to one another and acting on what we hear. Hopefully, as our leadership steps in, and again, probably appropriately, they will do better than what I see shaping up here right now. So again, my advice is take that judiciary set of recommendations. Let's act on those today. Don't give up your gavel unless you're going to move on that right now. Keep it till midnight. I will commit to continue to work to bring provisions forward during that period of time. And hopefully that demonstration of action will then permit our leadership to believe that this conference committee is actually going to get this done. Right now, if I'm them, and I'm looking at 5 days, wow, I don't think it'd be responsible for them to keep putting that responsibility in us. So, Mr. Chair, that's my response. And I suspect that will engender all sorts of other response, and we're going to engage in a rhetorical conversation and waste more time. And I will sit here and respectfully listen. But my advice is solid advice. Move toward each other, not away, not constantly posturing.
Representative Becker-Finn.
Thank you, Mr. Chair. And as you know, we had a conversation this morning. On the House side, we do have a bright line distinction between the judiciary and civil law provisions and the public safety provisions. And in that spirit, myself and my Vice Chair Moeller, prepared an offer. And in the spirit of transparency, we'll get that posted soon. We did send that over to you. I know it was right before the hearing, so I didn't expect that you'd be able to respond to a global offer immediately. But I do think we're not that far away on this half of the bill, and just want to commit publicly that my team is ready to work on those provisions and get that done. I think it's within our reach. I think that there are a number of items that we obviously still need to work on, but our team is ready to do that, and hope that you will remain open to, I know the split in the bill isn't ideal for the Senate side, but I do think that we can see some success today, and we'll remain ready to work as long as you have the gavel and into tomorrow until we get this done. But I think it's absolutely possible, and hope that you will maintain that spirit of working towards agreement as well. So thank you, Mr. Chair.
Thank you, Representative. Senator Matthews.
Thank you, Mr. Chair. So first, I want to commend you, Mr. Chair, for the work that you've done so far on this conference committee. You've stated your position very clearly and how you wanted to approach the bill. You've done that consistently, and you stated last week that until we had an allotment from leadership on what we were to spend, that was to be the guiding principle of where we'd go. And so that came out late Sunday night, I think became public Monday morning, and in less than a day, you had a very strong global offer on all components of the bill for the House to review well in advance and have this discussion. And the allotment that we've been given means that we're going to have a final product that is closer to the Senate bill. That's just the reality of the agreement that the leadership's given to us. And our constituents have been very clear. They want us to support law enforcement. We need to support the third branch of government. They need salary increases. We heard some of that reiterated again today. And you put together a very strong offer on it. So I know we're going to wait for a global offer. We got this partial offer back. We'll be reviewing it. I did note that I read only the first line to see that there is quite a reduction to judge and employee compensation right on the top line of the spreadsheet. So I know that you have, that we'll keep working together on this. You did put a very strong offer on the table to help us get to the finish line as quickly as possible. And I'd encourage all our members to keep working together to try to get a deal done to its conclusion. Thank you.
Any other discussion? I guess it's my turn. In order to review the events of the last few days in our conference committee, we failed to discuss the limitations that our leadership have agreed to. They agreed late on Sunday, made it available to the public on Monday, that for our division in funding, we are not to exceed $450 million over the next 3 years. Almost identical to the dollar amount that the Senate had. The House provision was spending a nearly, in their proposal, they presented a bill nearly $1 billion. $1 billion. Now, that's fine. They can make all the proposals they want, but really we're governed at this stage in our negotiations to the limitations that leadership has presented to all members of the legislature. So when it comes down to paring down, Senate bill, certainly at least the bottom line was as close as you could get to what their limitations were. The House bill had a lot to shave off and to move the largesse out of their bill. The spreadsheet that they have, and I haven't seen a new spreadsheet from the House, so I'm a little at a loss. I've tried to urge and cajole the House in order to put a global offer on the table. They did not, and so we decided to grease the wheels and present ours instead. Mr. Chairman, do you have an offer? Do you have a global offer? After all, we only have 5-6 days. The question I have, a little correction, the last moment we can vote is midnight on Sunday night, not on Monday at 6:59. So our time frame is even smaller. The Senate presented a global offer to move the ball and get it moving quicker. Mr. Chairman, do you have a global offer?
Well, Mr. Chair, I mean, we could play games here, you know. The Senate offered their Senate bill as the global offer. We offer our House bill as our global offer. You know, we could play this game, you know. The point is that we have consistently signaled that there are areas that we can work towards. You know, shifting the arguments, you know, around, you know, so now we were supposed to come up with a global offer last week when the Senate couldn't do that because We didn't have a target. The point is, let's get the work done. There are lots of things that we agree on. The House is more than willing to make important appropriations for both law enforcement and for community-based public safety. We're clear about all that. That's totally ignored in the Senate offer. I'm really not interested in this game playing. I'm really not. I'm really interested in building a bill. So if I'm forced to answer what my global offer is by someone across the table who offers their opening entire posture as their global offer, then my response is, my global offer is, same as you, our House bill. I'm telling you right now, this chair can move a lot away from where our House bill is. I don't feel vulnerable about saying that. That's different than this chair saying, I'm going to accept the entire Senate bill that was brought in. I just fail to understand how that even comes close to a decent way for us to negotiate. And my fear, I've expressed it, my fear is that people who have proper authority in our state relative to our work, which is our leadership, if the signal is that that's the best that Limmer and Mattiatti could do, then we'll find another way to do better. And frankly, I would support that. And it's a shame, because I think we can do really good work here, but it's not going to start by simply reiterating each other's positions and creating a scenario where the response is, do one body's bill only. We saw this bill 2-3 weeks ago. And aside from tiny little things that I pointed out here, I went through it, there's really no serious movement here. There's even movement away from one another. So, Mr. Chair, I won't repeat myself. I guess I've already said what I think needs to be said in terms of how do we objectively move forward and where the House position is. And having said all that, I've also said there's a judiciary proposal. Let's get it done. Let's do that. Keep your gavel so that we can continue to bring ideas forward to one another. I'll certainly work to put together proposals on the public safety side. But I am not walking out of this conference committee signing off on the Senate bill. That's just not happening.
Representative Mariani, I do a lot of negotiating, involved in real estate transactions a lot. When an offer is put on a table, the reaction is one of three things. Either one accepts the offer, one rejects the offer in total, or one counters the offer. In this case, we have a little different presentation. We represent two bodies, and we try to first examine each other's offers, and then realizing that we have to come somewhere in the middle within the limitations of what we're given by leadership. We adjust an offer and we wait for the reaction. I haven't seen your global offer. And if the global offer is the original House bill, gee, $1 billion of total funding is quite a ways away from leadership. And that means you don't have that money anymore. And we're not going to negotiate on blue sky here. We're going to stay within the limitations that the leadership has given us. I was hoping that we would have a reaction. I guess the reaction is it's a rejection with a couple of things. By the way, I want to thank Representative Becker-Finn for presenting the portion involving the court funding. We'll need a little time to digest that, Representative. And Representative Muller, we're working on an amendment that I think we have agreement on the surreptitious intrusion issue. But nevertheless, and we'll be posting that so the public has transparency. That's important for the Senate. That's why we took our global offer and immediately put it into the system so that the public could see what we're doing, what we're offering. We never expect the first offer to be totally accepted. It's not the way it is. I'm sure the Teamster president over there certainly understands negotiations too. And so I guess I'm just plain disappointed that we don't see a global, not a half offer, but a full-fledged, full offer by the House at this phase. Having such a small time window left, we really thought that after a few days, gee, we had a partisan convention. Yeah, we did. And we still got our global offer put together the very next day. I don't know what the House did over the weekend. I hope you enjoyed yourself. But I don't see that they have one. Senator Osbeck, did you want to join this?
Thank you, Mr. Chair. I just wanted to clarify something. So my understanding, Mr. Chair, is that leadership, which included House DFL leadership, agreed to a global number for this bill during the weekend, and your bill, which was agreed, which followed the direction that the DFL House leadership agreed to, your bill complies with the financial component that really is what we've been waiting for all week. Is that correct, Mr. Chair?
That's correct.
Okay. So, and I understand, Mr. Chair, I have been a chair of a committee for quite some time. Haven't been here for 32 years. But I do know you don't start throwing things against the wall in an omnibus bill without knowing what your target is. Oh, I'm sorry, we can't use the word target, can we? But our suggestion, I guess, is what you would call it. And then, Mr. Chair, I just want to clarify one additional point. The House proposal that's been put in front of you today is at $1 billion, which is wildly outside of the target, the suggestion that House DFL leadership has agreed to. Is that correct?
That's correct.
So, we can talk for 20 minutes and be as derogatory as you want to be towards the Senate for having the nerve to go to an event over the weekend. That doesn't push the ball down the field. That doesn't create an atmosphere where the majority party on this side of the table feels necessarily comfortable with. I'm sure it was very entertaining and fun to make the point. Doesn't help you. Just drives a wedge between the two individuals sitting next to each other as far as I'm concerned. I'm willing to certainly continue and move where we can and find agreements where we can. But to just slap $1 billion proposal on the table, which is completely outside of what the House DFL leadership has indicated, is irresponsible. It's flat out irresponsible, and it's not getting the job done. So if we want to point fingers, we certainly can. But, Mr. Chairman, I appreciate the fact that even though we all had a busy weekend, we had a proposal on the table yesterday afternoon that was compliant with what leadership in both bodies has agreed to, in both bodies. And I appreciate the fact we got the job done. Thank you, Mr. Chair.
Representative Becker-Finn.
Thank you, Mr. Chair. And I do want to clarify that the Judiciary and Civil Law offer that was shared with you all, and we'll get it posted as soon as we can publicly as well, that does comply with the targets proportionally to the provisions as far as what the numbers were in the bill, our initial House bill. So it was some major cuts, some major moves towards where we need to be to keep it within the targets. And so I do want to make that clarification that the judiciary offer that is on the table is within the targets proportionally for the bill.
And Mr. Chair, thank you, Representative Becker-Finn. I appreciate that, and I appreciate the fact that we did get that here just a few minutes ago. But when your chair specifically throws $1 billion on the table saying this is the deal, and it's wildly out of compliance with the agreement, I'm sorry, it really does cut your case. But I appreciate the fact we have progress in that area. Thank you.
Mr. Chair.
Representative Mariano.
Mr. Chair, I get the strategy of selective hearing, and so I'm hearing quite a bit of that from the other side. So let me just repeat what I said so that I can be really clear to you, which is if you listened, what I said was that we have a judiciary proposal that's a good one. And my advice is to take it, negotiate over that particular provision. Do not hold our courts and our public defense constitutionally required of us at the mercy of the other parts of this bill where, frankly, your offer has not even begun to respond to. With all due respect, the Senate's desire to only do this as a global offer does not require the other body to do a global offer. We began on the House by trying to move until senators decided they couldn't attend public conference committee meetings, trying to move very distinct pieces because that's how you often build bills. You all know this. That is what the House is continuing to say. That's why my advice is don't give up your gavel. You may not get it back. While we continue to do our work of putting forward proposals that, of course, have to fit within the targets that our leadership has set for us. Of course. I don't even know why that's being debated. So we're not going to get anywhere with selective hearing. We're going to get somewhere by building this bill. And if we signal that we're not going to build the bill, someone else will. That's all I'm saying.
Well, we're coming down to a little bit of a stalemate. Not on issues, but on process, it appears. We had hoped that there would have been a global offer from the House that is yet to be materialized. I want to thank Representative Becker-Finn for doing her part as chairman of the Civil Law Committee in the House. I'm considering a recess at this time, but I would like to see the House present a full offer, not a half offer. And if we don't see the full offer, we'll simply adjourn for the day. Because quite honestly, we can keep talking back and forth for the next hour that we have. But it doesn't seem to be too fruitful right now. So I move that we recess with the condition that I just mentioned. We're done.